just joining us, I'm Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center here at the SMU Dedman School of Law in Dallas. And I'm so happy to welcome you today to another in our Star Justice series. For those of you who don't know the Deason Center, we're a research and policy center. We do research for reform. We think along a Statz, stories, and change model. And we focus on three things. We focus on the delivery of the right to counsel for people who don't have money to hire their own lawyers. We focus on the operation of prosecutorial charging discretion, mostly screening and charging. And we think about what goes on in our nation's small tribal and rural communities. We try to hold research and reform up in those areas, and our own work deals with problems of lawyer scarcity, access to counsel, and the need for robust strategies to recruit and retain lawyers to serve in our nation's rural criminal law deserts. I am thrilled today to have with us Dr. Michelle Statz, who's a legal anthropologist whose work is just fascinating. I've had the pleasure of following her now for a while. She does the most interesting work about judging in small places. She goes all over, just came back from Alaska, in fact. And we're thrilled to have her here today to be talking to us about some of the work she's done on judging.
Thank you so much, Pam. Can everybody hear me okay? I think so. All right, so as Pam said, my name is Michelle Statz, and I'm an assistant professor at the University of Minnesota Medical School, and I'm affiliated faculty with the University of Minnesota Law School, and I'm an affiliated scholar, I'm trying to get all of this straight, with the American Bar Foundation. So I'm going to start sharing my slides. I think it's much more interesting to look at pretty pictures than it is the speaker. So to give you a little bit of background information, can everybody see that okay? So I've been conducting research on rural access to justice since about 2017, and there are not a whole lot of us who are doing empirical research in rural spaces, but it's important to me to start out by saying that I work across northern Wisconsin and northern Minnesota, which has a diverse array of sovereign nations and very well-established Southeast Asian and Black and Latinx communities, and a wide range of perspectives and identities and political opinions. And there are also very diverse economies spanning this region, and it's a very jurisdictionally complex space as well, because Minnesota and Wisconsin are both public law 280 states. So when I say I work on rural access to justice, it is still in a fairly limited region. So I don't necessarily know that all of this will translate to the rural spaces in which you're working, but I would love to hear how others interpret this work and if it does resonate with them. So I'm going to see if I can advance my slides. Okay. There we go. So in 2017, like I said, I began a mixed methodological project that explored how low-income individuals conceptualize and mobilize the law in the Northland, which is how northern Minnesota and northern Wisconsin is kind of colloquially described. And this work also documented the unique contours of lawyering and judging across the region and across different tribal, state, and professional institutions. Some of these institutions have very imaginative paintings in them. So I would just like to draw your attention to the mythical beast that's displayed very prominently in a courthouse in northern Wisconsin. I don't know if anyone can fill up the chat, but if you can guess what that is, I'd love to see it. And if you can't guess, it is the hodag. So over the next 3 or so years, I conducted about 200 individual interviews with public and private interest attorney or private and public interest attorneys, tribal and state court judges, local stakeholders, and low-income community members. And many of these interviews led to more long-standing research partnerships with over 15 tribal and state courts, as well as with the Lakota Ojibwe University. And my research team also conducted focus groups and nearly 230 individual and household surveys. Many of these data were used to create legal needs assessments on behalf of local legal aid organizations. And then because I'm an anthropologist, I also do what is called participant observation, which is kind of glorified hanging out. It means that I spent a lot of time sitting in courtrooms, visiting factories, mines, community centers, libraries. I did a 24-hour ride along with the EMS, which I will never do again. So that was a good lesson learned. I'm discussing that research though, because it ultimately informs everything that I do now. And it had everything to do, very unexpectedly for me, with feelings. So specifically, I realized that what people wanted to talk about and what I ultimately felt very compelled to learn about was how it feels to try to access justice, as well as how it feels to try and administer justice. And I don't think I can really quite illuminate that without talking about the context in which these feelings arrive, or specifically this sort of state by state context, and how this is implicated in class and in space. So moving ahead here, as you can see in Wisconsin, with the exception of Milwaukee County, Wisconsin's northernmost counties and sovereign nations are steadily and increasingly low income. And now, while Minnesota has one of the lowest poverty rates in the nation, in the past 20 years, its poverty has increased, particularly, as you see here, in the rural north. Now, there's a lot to be said for why this poverty exists, from ongoing impacts of settler colonialization to sustained disinvestment in rural infrastructure and even climate change. But I want to talk about rural poverty today because it's intimately linked to rural justice gaps. And I suspect I'm preaching to the choir here, but please hear me out. So we know that 10 million rural Americans, likely more at this point, have incomes below 125% of the federal poverty line. Yet on average, only 14% of rural individuals receive assistance for their civil legal problems. This is a rate less than half the national average. So when we think about, say, rural health disparities, we absolutely have to think about rural civil justice gaps as a critical component of that picture. Now, a lot of people rightfully want to explain justice gaps as a matter of legal deserts or growing rural attorney shortages. And this is absolutely critical because we know that presently only 2% of all solo practitioners and small law firms are located in small towns. And then unsurprisingly, there are even fewer legal aid attorneys. Yeah, well, attorney shortages are hugely consequential. This broader context also matters. And until my work, no one had really empirically considered other socio-spatial barriers when it comes to rural access to justice. Now, here's what showed up in my data. For one, in addition to attorney shortages, rural communities also contend with profound shortages in health and mental health professionals, educational opportunities, treatment centers, affordable housing, and other critical supports. This makes it very hard to point someone in the right direction if their legal issue has to do with, say, chemical dependency or a landlord-tenant issue. There are also very physical barriers to getting to the courthouse or to meet with a legal advocate: distance, bad weather, bad roads, typically absent or very limited public transportation. We also know about digital barriers, and most of the talk, particularly within the pandemic, has focused on rural broadband deserts, but we know that limited self-service is also a huge challenge. And then I think it's important to highlight that in the region where I do research, state courts, no matter if you're in Minnesota or Wisconsin, are persistently underfunded and very often overlooked. And many of the rural tribal courts where I work rely on gaming dollars for funding. And that, of course, took a hit during the pandemic, and it hasn't necessarily recovered. And then finally, although many people cite tech as a solution to access to justice issues, my research has routinely and somewhat unhappily demonstrated that many of the innovations themselves can also be barriers. So whether an app or a legal help hotline or an online fillable court form, these things often turn out to be really urban normative, meaning they're designed by folks in urban areas with urban populations in mind. So they tend to presume that people will have smartphones, consistent cellular and Wi-Fi, public transit, and technological as well as legal literacy. And now bringing this all back, these barriers present a fairly devastating reality and one that has almost everything to do with feelings. So as we know, in the United States, the vast majority of individuals with civil legal needs end up representing themselves in court. And overwhelmingly, the rural litigants I interviewed talked about feeling ashamed that they couldn't figure out online court forms, or frustrated that legal aid didn't have the capacity to help them, or defeated when they finally got to the courthouse self-help station and it was closed. One person likened the process of representing himself to going to the doctor and being asked not only to diagnose yourself, but to figure out your own course of treatment. Another person told me, one mistake on those forms will cause someone at the courthouse window to tell you to start all over again. And then you think, what happens if I screw this up? Will I lose my kids? So it's really important to highlight that oftentimes these individuals are in crisis. So when we talk about the impacts of having a civil legal need, I think we have to remember that in rural areas, there's also the compounding stress of trying and oftentimes failing to access even the most very basic self-help supports. Now, getting to the heart of this conversation, the other theme that emerged very prominently in my data was how it feels to try and administer justice in rural areas. So I have a very healthy amount of deference towards tribal and state court judges. And the thing that still surprises me was how incredibly forthcoming these individuals have been with me about their lives and work. I think there is a special kind of stress placed on rural judges, the majority of whom, at least in Minnesota and Wisconsin, are in 1 or 2 judge courthouses, have an enormous backlog of cases, and who also experience the burdens of living and working in an area where people kind of know everyone and know you. So I have to use a cuss word right now. I'm giving everyone a warning. So for instance, one judge who participated in my research said that on his first day on the bench, a man at the back of the courtroom stood up, shouted his name, and said, "How the fuck are you?" And I think this is a very funny anecdote, but this familiarity matters. So not only do rural judges often know the individuals before them, but they also have a very intimate understanding of what rural precarity or rural marginalization means in their own lives and work. So for instance, one judge said, some counties have alcohol and drug assessors and counselors and treatment facilities and inpatient treatment, and we have nothing. And stuff requires insurance money. No one has insurance here. I want to send some of the defendants to batterers groups, but they don't have anything like that here. No victims groups, nothing. None of those counselors are available. So there's something that emerges really powerfully in this data. It's not only that judges observe the legal consequences of limited services and long distances and the stress of depressed local economies. It's that the suffering is often something they themselves experience, and that often goes unmitigated in rural areas. So one judge said to me, quote, "We don't have a lot of social events, and I don't have another judge here where you can go, Jesus, this is getting me down. I'm getting trauma. I get secondary trauma and I can't take it anymore." And another said, "A lot of these cases I can't handle without just about crying. And we're supposed to be dispassionate and neutral, and you never show emotion. And that's the thing with mental health, we don't have any resources here either." So I have to tell you, this is where I used to typically wrap up my presentations, and it was a real downer for the audience. But during the pandemic, I had the, I guess, forced opportunity to pause fieldwork and think a little bit more about the data that I had collected. And the one thing that felt very close to my heart, but that I wasn't quite sure how to make sense of, was the way in which tribal and state court judges talked about love. Now, they didn't always use the word love, and in fact, they had a very steely-eyed perspective about the places where they lived. So, for instance, when I ask judges, is your community a healthy place? People would inevitably talk about opportunities to be outdoors and active, and in the same breath, discuss the opioid and meth epidemics or intergenerational trauma. But judges also talked about this being home and of having a real relationship with a place and a real concern for the people who came before them on the bench. And I started to think that this kind of love, which I've since theorized as place-based judicial intimacy, might have an impact on pro se litigants, something that could even be measured, and that this might, point to a more rurally relevant, actionable access to justice solution. So I pivoted. And in 2020, I got a grant from the American Bar Foundation that allowed me to start investigating this in earnest. And for the next 15 months, I and a team of really wonderful student research assistants conducted intensive fieldwork across 7 collaborating tribal and state courts. 6 of these courts were located in rural and remote regions, and one was in Duluth as a more urban counterpoint. This was a small sample size, but I think it's important to know that collaborating judges were fairly evenly split by gender, by non-native, native, and non-native identity, and they really spanned judicial ideologies and approaches. So this research was fairly intensive. It included hundreds of hours of audio recorded in-person courtroom observation, ongoing interviews and daily debriefs with judges, and extensive surveys with litigants. I also interviewed 4 other tribal judges who didn't formally collaborate on the project, but who still wanted to share their experiences. Now, I situate the work of all of these rural judges in the literature on active judging, not activist judging. That's something very different. Active judging refers to what judges can or potentially should do when parties are unrepresented. It includes judges adjusting procedures like order of testimony or evidentiary rules, judges explaining law and process like how to make an objection or what counts as evidence, and judges eliciting information from litigants to help develop a full factual record. Now, there's a lot of potential here in terms of access to justice, and active judging has been put forth by some scholars and policymakers as a kind of judicial role reform that would help address these profound justice gaps in the United States. But as many of you may know, there are a ton of gaps in this research. So until my work, no one had studied active judging in rural courts, no one had looked at it in tribal courts, and no one had evaluated how litigants themselves experience active judging anywhere. So to me, this feels like an incredible loss, particularly when we think that so many rural, tribal, and state court judges have basically been doing kind of ad hoc or default active judging for a very long time, meaning that in the absence of attorneys and accessible self-help solution, there's just the judge. So I'd like to talk with all of you about what I've learned so far and what I still want to learn. First of all, it's very clear that the active judging I've observed is solidly informed and motivated by rural place. It is very intentional. And if you read the article that was circulated along with the link, you'll see a lot of different examples of what this kind of judging looked like and how it was kind of inflected with references to place or shared place attachment. So as you can see here, Judge Isabel referenced place to show a kind of shared understanding, not just to connect with the litigant before her, but also because she recognized this connection builds trust and confidence in the court. I think this is really significant, particularly if we think about the work on procedural fairness, which is evidence that feeling heard and confident in the process is just as important to litigants as the case outcome. But of course, and I'm sorry if this offends any judges in the audience, just because a judge says something is happening doesn't necessarily mean that the litigant experiences it in the same way. So to better understand that side of the coin, we conducted over 100 surveys with litigants whose cases we observed in court. And one of the first things that I wanted to evaluate was whether or not there was concordance between place attachments, meaning did a judge in X court value the same elements of place as the litigants before them did? And ultimately, and I love this slide, we received a really lovely kind of compelling redundancy between judges and litigants in tribal courts, which you can see in the word bubble on the left, and those in rural state courts on the right. And what I like about this slide is that there's also a kind of like temporal aspect to these data, or a sort of seasonality. So you can tell potentially that we did this research largely in the fall, which is when Manoomin happens, or the harvesting of wild rice in different sovereign nations that are Anishinaabe. So the more pressing question for me, however, was whether litigants thought that a shared place attachment or experience of place was as important to accessing justice as judges did. I also wondered if they thought other axes of identity like race and ethnicity or gender might matter more. So here I was directly I don't do very much in academic medicine, in case you couldn't tell, but I did find that the medical literature on concordance was really helpful. So this is a body of scholarship that evidences that a shared demographic attribute between a patient and a provider, like gender, race, or language, leads to better access and healthcare experiences. And it may surprise you to learn that there is almost no literature in law or socio-legal studies that considers this particular dynamic between a litigant and a judge. So here's what we found. Overwhelmingly, place-based connection really matters to litigants. I was struck by this slide, and this is across both tribal and state courts. Things are a little bit less consistent when it comes to gender and race or ethnicity. This was also a very surprising finding. So these are really striking results, particularly if you're as interested in place attachment as I am, and it's only the beginning of this study. For now, however, I think that these data offer us a few things. First, and for judges themselves, I think it's helpful to have a language for practices like active judging. So when I share my data with collaborating judges, some will say, oh, yeah, that's exactly what I've been doing. And for them, I think these data really remind them to keep making those spatial connections or referencing those shared place attachments with litigants. But for other judges, I think it's been very helpful in terms of making the sort of cognitive or strategic connection between finding shared place attachments on the one hand and getting good facts and building confidence in the court on the other. And while I don't think this takes away the secondary trauma that I mentioned earlier, I do think that seeing these data and subsequent publications and presentations has underscored for my collaborating judges the real value of what they're doing. And this also has implications for job satisfaction and judicial wellness, I think we can also see the value of this practice for pro se litigants, namely that place-based active judging appears to offer a real sense of access. And this powerfully counters the feelings I described earlier of shame, frustration, and distrust. Ultimately, in these surveys with litigants, which we thought would take just 15 minutes, but often took 45 minutes, individuals really shared extensively and with a great deal of reflection what it meant that a judge understood where they were coming from in terms of place. Accordingly, I think these findings are really relevant to other justice settings, such as healing to wellness courts and treatment courts. And finally, this project, I believe, has much broader implications beyond the court system. Most important, it demonstrates that the rural and indigenous access to justice innovations that we should be looking to replicate likely don't come from tech companies or state and federal level policymakers. Instead, the collaborative, place-based work of rural, tribal, and state court judges is successful, and it has incredible potential to transform how we understand access to justice. So to pursue this further, over the next 3 years, I will be conducting a more expansive study that systematically evaluates place-based active judging across still more tribal and state court jurisdictions, across a wider variety of judicial positionalities, litigant identities, and case types. And this project is funded with another National Science Foundation standard research grant. So if anyone wants to participate in this research, please let me know. But for now, thank you so much for this opportunity, and I look forward to hearing from you.
Thanks, Michelle. That was wonderful. I really appreciate it. So interesting to hear. I'm going to ask folks if you are available, go ahead and put your cameras on. It's always, actually, we can't see you in this version, can we? Never mind. I'll take that burden off of you. But if you would please put your questions in the Q&A, and we'll answer them. I'm going to take the moderator's privilege for a minute and just follow up with a couple questions I had. On your survey data, did you survey judges and litigants, or just the litigants?
Just the litigants. We did formal interviews with judges, and then every day, sometimes multiple times a day, daily debriefs with judges.
And I'm curious, do you know whether the participants' perceptions were consistent with what you might expect in terms of outcomes? In other words, how much of do we know how much of this is a sense of what's happening and how much of it bears out in outcomes?
That's why well, to an extent, yes, right? Like measuring outcomes of case decisions is phenomenally complicated. But that was certainly one of our survey questions. And actually it was multiple survey questions because we tried to get at it from a lot of different angles. So we asked, do you feel that the judge was fair? Are you satisfied with the outcome? Do you wish something different had happened? Right? So trying to make sure we understood the different dimensions of someone's experience, because there's I think, categorical difference between thinking a judge is fair and being happy with the outcome, right? Those two things don't necessarily equate.
So we have a question that I know is going to be of interest to this crowd about non-lawyer judges, and were the judges you spoke with licensed attorneys or not? Excuse me. And to what extent did their legal training or lack thereof influence the way litigants experience?
That is an excellent question. I love that question. And in fact, that's something that we've built into our updated survey mechanism at judges' request. So all of my collaborating judges are law trained except for one. And this was never brought up in the data. I've heard in different interviews a healthy amount of skepticism, sometimes in tribal courts where judges have a different kind of relationship with tribal counsel, or maybe on the bench, appointed to the bench for different reasons. But typically that has nothing to do with whether or not that judge has a JD, and a bit more to do with community politics. Although there's skepticism everywhere in every court.
Yes. Thank you. Well, so I'm going to flip it around and ask a question about non-lawyer representation, because that's another question that's been asked. Did you see in your either in your observations or in your conversations with judges and litigants, anything about the power of informal advocacy and or formal advocacy by non-legally trained representatives? And I'm thinking here, for those who may not be familiar, there are sort of two models. There are lay models, and then there are models that are people who are licensed paraprofessionals, who are not licensed lawyers, but who may have limited capacity, legal status to provide some legal services.
Right. So that's another question that I would have a lot to say on. In this particular subset of data, some of the tribal courts where I work do include tribal lay advocates, and this is part of my partnership with Lakudere Ojibwe College, is that they offer a tribal lay advocacy training program, but it is often, particularly in Wisconsin, very hard to recruit and retain tribal lay advocates, even though there's a high demand for it. And so I can honestly say I have never observed a court hearing in a tribal or state court that had a non-licensed legal professional or a lay advocate or anything like that. I've only ever observed individuals who might have a court-appointed attorney in a tribal court case in which the tribal court pays for an attorney for civil litigants or unrepresented or pro se litigants.
So, Michelle, can I sort of follow up on that then and ask relatedly? And I realize I'm jumping from one project to another, but
sure.
Would you talk for 5 minutes about this very exciting project you have going in Alaska? Because I think it's fascinating, and I know some of the folks on this webinar would love to hear it. We will come back to what we're talking about, but I don't want to miss this opportunity to share the work you're doing.
That's very kind of you to ask. I hope this is not contentious. I really love attorneys and I don't want to make anyone feel threatened. So I am additionally the PI on an NSF Civic Innovation Grant that looks at the really compelling, incredible work coming out of Alaska via Alaska Legal Services Corporation, the Alaska Native Tribal Health Consortium, Alaska Pacific University, and with incredible support from the Alaskan State Bar Association and Alaska Supreme Court. So basically in the past, however many years, Alaska Legal Services Corporation has been developing what we're calling the community justice worker model. It's something that's based on the community health aide and practitioner model, which has been around in Alaska for the past 50 plus years. It was developed by the Alaska Native Tribal Health Consortium, and basically it trains and employs individuals who are already embedded in rural, predominantly Alaska Native villages to provide different levels of health care and critical care in these more remote spaces. I shouldn't say critical care, but critically needed care. That's something different. And these health aides work under the supervision of other healthcare practitioners. And it's one of the most successful, culturally and linguistically representative and very timely and urgent forms of healthcare out there in these sorts of indigenous and rural and remote spaces. And the executive director of Alaska Legal basically said, why couldn't we do something like that when it comes to legal services delivery? Because she was running the numbers, and I'm sure like so many of us who understand how legal aid works, was recognizing that she was having to turn away one person for every one person that was given services by Alaska Legal. And it's very, very hard to recruit and retain attorneys in Alaska, and particularly in rural and remote parts of Alaska. So basically, with the support of the Alaska Bar Association and the Supreme Court, there was a waiver passed to grant a waiver for UPL, and they have trained over 100 community justice workers who are already employed by different organizations that are trusted and embedded in Alaska Native communities. So people in the wills division can be trained, or people in the lands division, excuse me, who are really focused on avoiding the fractionalization of Indigenous lands can be trained in wills via one module, or people who are already working at a domestic violence shelter can be trained in domestic violence issues. And these individuals then become legal advocates who can not only provide legal assistance on behalf of individuals, but they can now successfully represent them in state and tribal courts because of that, because that waiver was passed.
Well, thank you so much for that. I know Lauren has a question, and I'm going to get there in just a second, but I wanted to ask, since we are a criminal justice center, one of the things we think a lot about is the way these legal deserts, and you've written so eloquently about them as healthcare deserts and health determinants, right? But the way in which there is a nexus between the civil legal aid crisis and the criminal law crisis, the common thread, of course, being the utter lack of legal resources. And I wonder if you could talk for a little bit about what you're seeing and hearing from litigants and from judges about their attitudes toward whether there is a need for more lawyers, how they see that need, and what you think the prospects are for thinking about it. And I should flag here that we do a lot of geospatial imaging and trying to think about the different ways to treat place differently. Right? That we think a lot about the idea that not every rural place is the same, not every rural place will have the same solution to a crisis. Right. But one of the really important things you're doing is you're asking people in their own communities to talk about how they see their problem.
Right. I'm a big believer in those shared place attachments, right? I think that if we do want to acknowledge justice as an experience and something that is really, gosh, I want to get a little bit tangential here for a second, because I think in small communities, a negative experience in a court or a negative experience with a judge can ripple through a community and have profound impacts on confidence in the courts, just as a more positive experience does the same, potentially, maybe a little slower. But I think, so to your question, this is going to sound like such a cheap answer, but I think that, yes, there is an enormous public defender crisis, particularly in Wisconsin, where PDs are chronically underfunded. And also in Minnesota, although it follows a slightly different model and one that is arguably more successful. But in rural areas in both of these states, enormous backlog with huge implications for individual and community health when you think about rates of relapse and recidivism. And so it seems as though in the data, in both the law and medical professions, those pipeline programs really matter, right? In terms of recruiting and retaining attorneys who are committed to then returning to rural areas. And I don't think, and this is me as an anthropologist who really thinks a lot about context. I was just asked to speak to a law school class, and someone said, and I love this because it was a really well-intentioned question, but he said, why don't people in Alaska just encourage more students to go to law school in Alaska? And I was like, well, first of all, there's not a law school in Alaska. But secondly, we have to think a lot about the role of social capital, right? Like I am from a rural area. I never met an attorney until I was in college. It just wasn't going to happen for me. And we also don't talk enough about the fact that many, many college recruiters will never set foot in a rural community.
Right.
So I think there are incredible opportunities, and I don't want to present this doom and gloom version of rurality or rural America, but in terms of exposure and proximity and access, there can't be access to justice if rural kids can't access education, right? Like it's just as simple as that.
Well, and in fact, I'm I think Blaine just dropped one of our new policy papers in there, but something we talk about a lot and think about is, what does rural recruitment and retention mean? And number one, it doesn't mean full-time public defenders and prosecutors in many places. It means solo practitioners who do the civil legal work and the criminal work. It means pipelining kids, as you said, from high schools where rural kids typically have higher graduation rates into college, where we see urban kids, right? The graduation rates go much higher. It means recruitment efforts from college into professional schools. And of course, we know from the medical literature that there are ways, really well-proven ways, to bring lawyers to underserved communities. I want to switch the topic to underserved communities for a second and follow up with the question that was posted earlier, asking how this work about judging in place translates, in your view, beyond rurality. In other words, are there ways that people working and researching in other areas, and I assume here we mean geographically speaking, right, might be able to translate your work to their communities, whether it's a dense urban area or perhaps it's a sense of place that's based on origin, but perhaps, not contained. Do you have thoughts about that?
Yeah, I have a few thoughts. I don't know that any of them are going to be very satisfying. The first is that there are scales of place. So I'm thinking a lot about one of the unanticipated benefits of Zoom during the pandemic and moving hearings online was that some of the judges I worked with, both in rural and in the Duluth court, had access to people's homes, which, I mean, for better or worse, right? But suddenly, we were hearing comments about like the person's neighborhood or the person's, I don't know, all their plants or something, right? Like something relatively mundane, but that could still serve as a point of connection. And I hope this doesn't sound like a cheap answer, but I do think that the level of neighborhood really resonates. And this is where in the Duluth setting, and this is something we need a lot more data on, people were more skeptical of the judges' understanding or whether or not there was a shared understanding of place, because they would say things like, she doesn't spend any time in West Duluth. Like, I can guarantee that. Right. So, and I think that's really compelling data. And if anything, like if we really want to sort of operationalize this or challenge this idea of place-based active judging or engage it, then it would be interesting to try on, like if a judge would try on like, hey, what part of town are you from? Right? Like, where are you working? Oh yeah, I know that place, right? You have to know what you're talking about to begin with. But I think that if judges sort of appeal to a potentially shared understanding of place, that could have real purchase with a litigant. The other answer I would give to this has to do with Indigenous judges. I mean, we all know place is central to sovereignty and to identity in many Indigenous communities. And so some of the judges who I interviewed but did not collaborate with, or I didn't collaborate with their courts, served on higher level appellate courts or in urban areas. And so they talked about place when they identified a litigant who they suspected was Indigenous. And so even if that wasn't a shared place attachment, there was a certain kind of shared identity that recognized the significance of place. And so you can see this work out in different ways, in different settings, and with different identities that people hold.
Thank you for that. So I'm curious, following on the heels of that, to push a little more on this idea of Zoom and broadband, and talking a little bit about the value of place, but also of presence. And so, one of the kind of mixed, I view remote court as a very mixed blessing, often more on the negative side than the positive side. And I think as a pragmatist, half a loaf is better than none at all. So if you're going to talk to me about people being in jail with no access to courts or getting some video access, that's, I know which one I'd pick. But I I worry a lot that the push to talk about broadband as some kind of solution, whether or not rural places need a solution is a different question, but this idea that somehow broadband is a catch-all, fix-all for the problems of scarcity, and particularly of kind of professional scarcity in these very highly trained, rarefied environments. What's your thought about that?
I have a lot of thoughts about it, and I agree with you that it is a very mixed bag. And I've heard it's very interesting because most of the judges I interviewed talked with a great deal of sensitivity about how this cuts down on drive time. It allows someone who might be struggling to access childcare to appear for a 5-minute hearing, right? All of the things we already know. And I don't even know that I'm ready to share this with my collaborating judges, but it was really interesting to hear one judge say that and know it's true. And we can all agree that's true. That is a real benefit. But then to observe the judge in an incredibly focused and rigorous way over the course of the day and see the real tangible implications of Zoom fatigue, right? And just see how people get tired, how they get grumpy, how it's just so much more of a struggle to give unrepresented litigants that kind of active assistance in real time. Especially, we can talk about broadband, but is it consistent broadband, right? There's that too.
Right.
Are people losing connection? So I do think that it is part of a solution, but it is not the entire solution. I think it introduces, like we already know from others' work, and I know Victor Quintanilla does a really good job of studying this, that there are ways to mitigate the bias that is intrinsic in online hearings, particularly when we think about who does and doesn't have access, who does and doesn't have video, right? All of the ways that we can potentially mitigate some of that bias or make things more equitable. But it puts a real burden on courts that are already, I would argue, overburdened.
Well, and let me push a little more and say, did you have a chance to hear from litigants how they felt about the remote process? And going back to your point about bringing judges into their home, there's an enormous intrusiveness in that. Yeah. Particularly, it's not just the intrusiveness of allowing someone kind of a bird's eye view into your home, but for people who are at risk and may have other legal problems, again, particularly in the criminal space, which we've dealt with, there's enormous concern about what else judges and other litigants are seeing that they wouldn't have access to in a courtroom.
I agree. And the data really evidence, I'm thinking of other research data that are demonstrating this very compellingly. And I would also say, and this is something I've not thought very much about, but have been considering as I kind of ramp up for the next round of field work. It can also be fairly heartbreaking, right? For judges to observe some of the places in which litigants are living or existing, right? So visiting different treatment centers or support services, just to even be in the audience as an observer was sometimes felt frankly very traumatizing, to see, just an exposure and a kind of proximity that otherwise would not happen, and that is potentially very problematic for all sides. And I think, and I believe I wrote about it in the paper that was circulated, our data suggest a strong-ish preference among litigants for in-person hearings, particularly because that sense of trust and accountability and sort of relationality with a judge is something that many litigants seemed to value in both the civil and criminal contexts. I think that's unique to rural spaces, right? The likelihood of having more than one case before just one judge is much higher in those spaces. And I do think I might have fairly self-selecting judges, but those active judging efforts forge a real connection that changes the conversation with subsequent hearings. And so among those litigants, we did see a higher preference for in-person hearings.
That's fascinating. Well, thank you for sharing that. Let me switch gears a little bit and go back to this question about a sense of shared place and the ways in which it seems, at least in your group, that it might be more important than some things we traditionally think about in the urban space, right? In the urban space, we tend to organize our thinking about criminology and criminal justice around things like race, like class, rather than place. On the other hand, there has been some work done on kind of micro neighborhoods in urban areas. And you can see that, for example, even in some of the new policing initiatives. Dallas is doing some at 300 square feet at a time.
Right.
Do you have any sense that the how do I say this? That space is about proximity and scarcity, or is it about kind of a shared lifestyle experience? If you understand what I'm asking, I mean, what is it about place that makes it important?
Yeah, I don't know yet. I think I do, and this is where, so I struggle a lot because there is a very natural push for me to compare this work with more urban settings. I think that's just natural for us, right? We're constantly putting rural and urban in opposition, and how can rural speak to this and can urban speak to this? I personally am a little bit more interested in rural to rural to rural to rural communities, because they are so distinct and different. And so because of that, I'm moving out. I'm including, but moving out of Minnesota and Wisconsin for this next phase of research. But I think when we try to translate these findings to the urban space, my first hunch would be that class figures in much more prominently. So I have one judge who was originally a legal aid attorney on the Iron Range, and who lives on the same street as many of the individuals he advocated for when he did work in legal aid. And I think that's a very telling example, right? That sort of socioeconomic stratification doesn't necessarily exist in rural communities, not all rural communities, but in the rural communities where I work. Whereas my sense would be that in urban areas, there is more of a geographic and class divide. So I don't know that the findings can ever speak to an urban context.
So setting aside the urban context, though, I'm thinking actually more about the really profound differences in some ways between small towns where people are clustered in a relatively, street space, and kind of more broad spread frontier communities where there's really wide diffusion of populations.
See, that I don't think would make that much of a difference. I'm going a little bit off the cuff here, but thinking about the literature on shared place attachments, it often has to do with like a shared experience of place. And
rather
that
than the shared place.
Right. It could be a memory, a ritual, of something else, a different kind of engagement with shared place. And so in that regard, I think it holds across small towns and quote unquote frontier communities.
Thank you. So we had a question in the chat about whether there was any, actually we had two questions I want to cover. And I also want to flag that when you were talking, one of our staff, Blaine Scouse's grandma was the the judge in his local hometown court in a very small town in East Texas. And so there was like a sign on her door, when people could come and, where she was as a judge, and don't knock here, this is family time. But we have two questions I want to pick up on in the chat here. One, following on your conversation about Zoom fatigue, do you have suggestions about strategies for active judging, given that Zoom is going to be around for a while, and also strategies really concretely, beginning of the docket versus end of the docket? all these things about fatigue. Do you have concrete observations or suggestions that folks can take back to their practices and their communities?
I don't. I
That's
wish
allowed.
I could say something like have some coffee or I think I do not, although I'm really interested in creating, I'm failing at answering a lot of these questions, but I'm
No, you're not.
very interested in the idea of creating a community of practice among rural, tribal, and state court judges, because when I was finishing up my pilot research, I suggested with a great deal of nervousness on email, dear judges, would you be interested in meeting on Zoom together to discuss my emergent research findings? And I just figured these are such busy and important people. And within an hour, every single person had said yes.
Mhm.
And we met online. I shared my findings, and then they just talked to each other.
Mhm.
And it was probably one of the most meaningful moments of my research, because I think a lot about like professional isolation and absent resources, and the fact that you might not have another judge in the courtroom to talk to about Zoom fatigue and how they get through it. So that is something I'm really interested in developing, because I think it might provide some of the answers to that question.
Mhm.
But the other thing I will say is that I recently met up with one of my collaborating judges from that pilot research, and she said that since reviewing the data, we produce these big glossy court reports for all collaborating courts. It has compelled her to be even more mindful and strategic in every single hearing to engage in that place-based active judging, because she knows it's significant. That doesn't mean she's successful at it all the time or never gets tired, but I think just being able to review the data kind of reminded her of how valuable it is to litigants. But I'm so sorry that I can't answer the Zoom fatigue question.
That you don't have a solution to a national crisis.
No, it turns out I'm not that.
I can't imagine how I forgot to warn you that we wanted your answer on that. We have another question about whether you had any feedback from lawyers who were in the courtroom watching these pro se proceedings, and what their take was on what was happening.
Yes. So that's the book I'm working on.
Oh, okay.
I'm kind of toying. I won't get into it, but I'm always very not surprised, but struck by the ways in which attorneys in hearings, in civil cases in which one party may be unrepresented and the other party does have a private attorney or a legal aid attorney, it has been a very meaningful thing to observe the ways in which the attorney gives the judge a little extra grace when the judge is engaging in those active judging moments, right? And I have followed up with a number of attorneys to say, did I hear that right? Like you kind of laughed and whatever. But overwhelmingly, it benefits all of the courtroom work group when a litigant is getting appropriate professional assistance, wherever that's coming from. So it makes it easier for the attorney, makes it easier for everyone involved.
Yeah, I mean, I can say certainly, I'm nodding, and anyone on here who's been in criminal practice will know this. There's nothing worse in a courtroom than watching someone who's pro se try to defend themselves. And the judge is bending over backwards often, not always, but often. The DA is really in a very difficult spot because, there's not a lot they can do when they're watching things unfold. And it's a very painful experience. And I imagine one that judges also take home. I mean, it's hard to stop people from making bad decisions, even when they have a constitutional right to do so. And I would suspect that that's a piece of the trauma as well. They're trying to help and sometimes getting rebuffed. Yeah. So if you were to sort of think about what your research is telling you about place, do you think there's a, and maybe this is why this is part, I guess, if you're reaching out to other places, but what is the resonance of similarity in place rather than place specificity? And so I'm thinking here about the research on medical recruitment that shows that the strongest predictor of a rural medical practice is growing up in a rural area, but that doesn't necessarily predict which rural area you're going to go to, right? It's a predictor, but unclear of whether it's space specific. And I think there's a lot of evidence that says that a positive educational experience in a rural area is a big factor. Is it your sense that the shared experience of place is deeply space specific in a way that doesn't have any room for similar spaces? So, for example, if you think about someone in one Appalachian town versus another Appalachian town, right? They're going to be very, very far apart potentially, but the architecture of their lives, the geography of their lives, the relationship to state and local government are going to be very similar. Are you finding, or do you hypothesize that there's a connection there?
A really good question. It's a knotty question, right? I think the focus on place could come at the cost of other meaningful identity markers for a person. So I think about, say, an Indigenous judge who is a member of a sovereign Native nation in Oklahoma, who is on the bench in northern Minnesota. Very different geographies, right? But a shared identity in a different space.
Yes. Right.
And I think also about another, now maybe I'm just throwing all of my research to bits, but one of the judges I work with most closely is on the Iron Range. He's lived there for 25, 30 years. He's originally from Philadelphia. Right? So there's something, yeah, but I think I need to think about it more. I think sometimes that we fail to honor the way in which language figures into place-based identities and how important it is to speak that shared language. I think some of this might be reflecting on that research on concordance, right? The role of language concordance, although that's very literal, right? Like if you and your provider each speak, say, Spanish or, but I've been struck personally, and I'd love to hear your thoughts or thoughts from the audience on how my ability to speak rural grants me a different kind of access and trust from research participants than other scholars who I know who do research in rural areas. And there's a lot of different kinds of class signaling that goes into that as well. So I think it also matters that I'm from a working class background, first generation college student. I don't share any of those things with I don't usually share that background with research participants, but I think it grants me a sort of easy comfort and a real deference and humility with the people I work with. And I think that is actually something that's important in any research setting, but it's especially important in rural settings that might have a sort of a bit of hesitation or reluctance to trust, say, quote unquote, outsiders. So I do think that if you can if people can honestly, genuinely appeal to those different markers of place, I think they can practice just about anywhere, but it can't be forced.
So that's fascinating. And I'm going to refrain from calling out someone in our audience, but Bill, you know who you are. I'm curious to hear. So we have a really wonderful group of rural stakeholders who form our rural advisory board here, but we're in an urban environment in Dallas. We do an enormous amount of work in rural communities, but we are primarily not people who grew up in rural environments. We have a couple people on our staff who did. Some of us have lived in very rural areas for a while. And I can't speak for the experience of the people that we work with. I can tell you what our perspective has been, which has been that you have to show up, and that you have to be willing to listen and learn, and you have to come in from the perspective of, okay, here's what we think we understand. Tell us what we're missing. Tell us what we're overlooking. And I don't know whether we would have more or better access if we were in a rural area. Maybe we would. We've actually been blown away by how open and welcoming people are in rural communities. When we say we'd like to know more, we're interested in taking the work of public defense, taking the work of justice investment, taking the problems of rural prosecution and defense recruiting and doing something about that. When we say this is an injustice that we care about, I've been enormously humbled by how open and eager people are to work with us, even though we don't share their experience. So if there are barriers there, and I'm sure they are, I think we don't feel them. So I don't necessarily know if we know what we're missing, if you understand what I'm saying. But I have to say, we have been, again, we have a couple of projects going on. Some are somewhat at a distance, the geospatial mapping, the policy work. A lot of that has been, particularly during the pandemic, done long distance because you couldn't really go a lot of places. But we're doing field work in lots of places on problems of non-representation in criminal cases and what are the causes and what might be the solutions. And for us, I think a lot comes from being willing to put your boots on the ground and show up. I mean, that's been my experience. And if anyone is on this webinar who has thoughts about it, please feel free to jump in. But that's been, like I said, we've been very honored and very humbled at the extent to which people have welcomed us into their legal experiences and their community experiences.
Right. I think you nailed it. I mean, first of all, congratulations, because I think the longevity and the clear commitment of the efforts of the center is so clear, right? I mean, it's just so evident. And it doesn't surprise me that that would be the response from the folks with whom you're working. But yeah, like, you have to show up. And that's why this research is really hard. I mean, like, it is incredibly time and relationship intensive, which I will admit is very hard for me to communicate to my medical school colleagues. And it is also the joy of my life, right? Like, because it is such an honor to get to know people and get to share in their worlds, however briefly. Yeah, but yeah, you got to show up. Like, that trust is absolutely imperative.
And I guess I'll say, following on that, for those who are on this call and who work either in the world of technical assistance or courts or grant makers, I just want to underscore, like, 2 and 3 times everything that Michelle just said about time. We are gathering rural court records in some places where it literally takes hours sometimes to compile a full court record because everything's on paper still. It is an incredibly important investment. Again, on the criminal justice side, which is our expertise, rural communities are where jail populations are growing. So if anyone, if you don't care about it for any other reason, right? If you don't care about it for equality, if you don't care about it because these are your neighbors and the people who are supplying your food, right? You should care about the fact that, this is a place where it's clear that there's a need. And yet trying to get people to understand that doing the same project in 3 rural courts as opposed to 3 urban courts, it's not just what it would cost in an urban area plus some transportation. The costs of doing that work are exponentially higher. I think the rewards are exponentially higher, particularly right now where there's so little research been done. But I agree, it's very hard to convey the amount of boots on the ground time that's required.
Right.
So we are just about at the end of our time. And I'm going to leave with one. There's a lovely question in the chat, and so I'm going to read it and let you answer before we sign off. And just before I do, I will, my team will kill me if I don't mention this. We have a wonderful event coming up on April 4th. Valina Beatty from the ASU Law School will be speaking about her new book, Manifesting Justice, which is all about wrongful convictions, particularly of women. And she'll be talking about one of her clients who was convicted in Mississippi of a horrific crime that she didn't commit primarily because of her sexual orientation. And so that program will be offered both on Zoom and live here on the SMU campus. And we do hope you'll enjoy us. We'll join us for that. We'll drop a chat link here in a minute. So folks, if they want to register, can join us. And also, please don't forget about your CLE credits if you're looking for them. So let me ask you the last question. I'll give you the last word. The question is, would you say that place-based connection is secondary to human connection? I think that most people just want to feel heard and not feel like just another case on the docket to check off the list. So the place-based connection is a door into the deeper personal connection. Would you agree?
Julia, I think that's beautiful. Are you looking for a job as a research assistant? I think, yes, let's go with that for now. I think place is a phenomenal entry point, particularly in rural settings. I don't think it is the only entry point for connection, but that connection needs to be there. You're absolutely right.
Well, with that, let me thank you all so much for joining us. And again, I want to thank Dr. Statz. This is Michelle's second time joining us, and we are so lucky to have her as a colleague and a friend.